It's captioned Ferrellgas versus Houlihan Loki. Your appearances, please.
Your Honor, I'll start. Sarah Rathke and Stephen Lerner from Squire Patton Boggs for the Ferrellgas entities, and also our local counsel, Jim Griffin, is here, although I am admitted pro hoc into your very fine court, Your Honor.
Okay. And defense?
Kirk May and Philip Greenfield of GM Law PC, Your Honor, for Houlihan Loki Capital, the defendant.
And that is with Mr. Chen, C-H-E-N?
That is correct.
Okay. All right. We've got a few motions we can address. I don't know if you were more interested in limiting this, but looks like we've got several things on file. Got a motion to extend time for discovery, the motion for a protective order regarding Matt Neiman deposition, motion to stay proceedings pending arbitration, and a motion to dismiss. They're all defense motions. Which were noticed and which do you want to go with?
They've all been noticed, Your Honor. We think it would make the most sense to begin with the motion to dismiss, followed by the motion to stay, and then depending on the resolution of those two motions, the discovery motions, I'll call them, the extension of time and the protective order motion.
All right, go ahead.
Your Honor, I'm going to argue and address the motion to dismiss, and then Mr. Greenfield is going to address the motion for stay. In the case, Ferrellgas has asserted a single claim, Your Honor, against the defendant. The claim is for tortious interference with an attorney retention agreement and related fiduciary duties that an attorney owes to a client. The agreement, the fee agreement, retention agreement at issue is between Ferrellgas and DLA law firm. If you'll recall, Ferrellgas also has a case against DLA that is in your court, and I believe before Your Honor. That case has been stayed and ordered to arbitration by Your Honor. That case involves the same breach claims against DLA as those breach claims that form the basis of the tortious interference with contract claim that Ferrellgas asserts against Houlihan Loki in the present case. We moved to dismiss, Your Honor, on two grounds. A required element of tortious interference is that there be an inducement by the alleged tortfeasor, and that the action by the alleged tortfeasor is not justified. There are two grounds that are asserted as being a basis for the breach. The first being Houlihan Loki and DLA entering an attorney-client relationship, and the second being the disclosure of information, confidential information, from DLA to Houlihan Loki. And I should note, Your Honor, in my argument today, I'm accepting the various facts I state for purposes simply of these motions, because they are reflected in the allegations that frame the motion. But by doing so, I just want it to be clear, we're not agreeing nor admitting those particular facts or allegations. The Ferrellgas, in its opposition to the motion to dismiss, Your Honor, in their factual background sets forth the underlying operative facts, I will call them. Those are relatively simple, as follows. On July 27th of 2018, Ferrellgas retained DLA law firm in connection with Ferrellgas's negotiations with bondholders concerning a possible restructuring. In August of 2018, Houlihan Lokey sought to become the financial advisor for Ferrellgas on that restructuring transaction, potential restructuring transaction. At that time, DLA and Houlihan Lokey, according to Ferrellgas's filings, I'm quoting now, already had an ongoing attorney-client relationship with DLA. So that relationship obviously predates the relationship that Ferrellgas had with DLA. The claim, again, Your Honor, is that Houlihan Lokey, it was a breach of DLA's fiduciary duty, contractual duty, to even take the representation of Houlihan Lokey, which apparently already existed before and predated DLA's relationship with Ferrellgas. And the second basis for breach is that DLA allegedly gave confidential client information of Ferrellgas's to Houlihan Lokey. And if you'll recall, Your Honor, in the case that I mentioned previously, for the record, it's 20CV3359 in Your Honor's court. The basis for the breach there is not surprisingly identical to the basis for the breach in this tortious interference case, and they reference the particular Kansas ethical rules that are in play and raise the ethical obligation that DLA had and supposedly breached. And those two obligations are under 1.6 and 1.8 of the Kansas Rules of Professional Conduct. Those rules concern providing confidential client information to third parties without the consent of the client. And then 1.7 and 1.9, they also rely on, which prohibits representation of clients with adverse interest. What's not in dispute and is not a factual issue, certainly, Your Honor, is that by virtue of having an attorney-client relationship with DLA and Houlihan Lokey, DLA had certain ethical obligations and fiduciary duties to each. And among those ethical obligations were an obligation to determine and satisfy itself, DLA satisfy itself, that the concurrent representations were permissible and did not violate the conflict of interest rules. And secondly, DLA law firm had an obligation to satisfy itself under the ethical rules that it was not sharing confidential information with third parties without the consent of its clients. And it's important, Your Honor, to keep in mind those obligations, accepting the allegations, existed with respect to not only Ferrellgas but DLA as well. In accepting the allegations in their filing, the relationship with Ferrellgas, the attorney-client relationship, in fact, predated the attorney-client relationship that DLA had with Ferrellgas. And it's important, Your Honor, to remember those ethical obligations are imposed on attorneys, not clients, and there's essentially regulate the practice of law. and impose obligations on lawyers. And the allegation is that the breaches were a result of a lawyer violating ethical rules. And I've identified the two areas of ethical rules that they claim were violated that resulted in the breach, which is the basis of the tortious interference claim. And it's important, Your Honor, also to remember, in this instance, the conduct that is the breach, the alleged breach, are uniquely attorney issues, calls, and judgments. Clients are not charged with determining whether, when they ask a lawyer for a particular set of documents, and the lawyer says, okay, here, fine, you can have them. Well, it's fair as a matter of law that a client, or even a prospective client, can rely in that instance on the attorney's judgment and discharge of the attorney's obligation when the attorney concludes that it's permissible to provide that information to the client that requested it. Same with determining conflict of interest, Your Honor. Clients don't determine conflicts of interest, and the structure of the rules and the policy to ensure that people are relatively free and have access to legal counsel is such that you would not expect a client to evaluate and undertake a conflicts analysis. And there's no allegation here that Houlihan Lokey withheld relevant information that was needed to make a conflicts determination. And there's no allegation here that Houlihan Lokey precluded in any fashion DLA from getting consent from Ferrellgas to provide this information to Houlihan Lokey. So it's in that framework, Your Honor, that I think the issues of inducement, breach, and justification have to be evaluated. The Ferrellgas argues, and essentially it's the beginning and the end of their argument as well, justification is a factual issue. And I think it's fair to say that in more instances than not, justification would be a factual issue to be resolved by the jury. But this is not one of those situations. First off, and we cite this in our reply papers, Your Honor, the McCormick case makes clear that conclusory allegations, okay, that don't follow from the description of what happened, those conclusory allegations do not have to be accepted by Your Honor. And when inducement is alleged and justification is alleged, those are conclusory allegations, Your Honor, and they're not supported by and don't follow from the descriptive story, if you will, in large part in recognition and because of the nature of the relationships that are involved here, the attorney-client relationships. So we're not raising any factual disputes that Your Honor has to resolve. Our motion does not do that. What our motion does do, Your Honor, is it raises and requires the court to determine the legal significance of the attorney-client relationship in the context of inducement and justification. Can a client or a prospective client be said to have caused, in other words, induced an attorney to breach that attorney's ethical obligations to another client? And I'd suggest, Your Honor, that the answer is no. The client cannot do that. That's an attorney obligation. A client cannot induce an attorney to violate an ethical rule that the attorney then violates, and another client has a claim against the attorney's first client. So it's the legal significance of that relationship, Your Honor, that is determinative here. It's not resolving any factual disputes. It's the simple matter of what does it mean, the fact that the practice of law is regulated and clearly define an attorney's obligations and the relationship between an attorney and the client. And again, the policy issues are important as well, Your Honor. This doesn't leave Ferrellgas without a remedy. As we know, Ferrellgas is suing DLA law firm for the very same breaches that they're suing Houlihan Lokey for in this case. And also, if permitting a claim like this would put a burden on a client that it would be impossible for the client to discharge it. Imagine if every time a lawyer undertook a representation and it turns out the lawyer missed a conflict, then not even the second client, but the first client would have a claim against the second client for inducing the lawyer to breach her or his ethical obligations to their first client. And I don't think it would be wholly inconsistent, Your Honor, with the regulation of the practice of law and the relationship between attorneys and clients to permit a result like that. That's the first basis for our motion to dismiss, that as a matter of law there cannot be inducement or lack of justification in this situation given the nature of the relationship at issue. And I should add, Judge, the Kansas courts do look to the restatement second and recognize that the various factors that are commonly cited as being to be considered in evaluating the lack or absence of justification, those factors don't apply when there are relationships, the nature of which justify, for example, somebody following an attorney's advice, for example, something like that. And we cite that in our reply papers, and that is provided for in the restatement. So I don't know if you have any questions on that particular piece of it, or if you want me to go ahead and finish, Judge, with the second piece. I'll finish, unless Your Honor has a question.
You're still on your motion to dismiss?
Yes, I am, Your Honor. I am, yes. Okay, fine.
Go with the motion to dismiss, and then we'll hear from Ms. Rathke.
The second basis for dismissing is that the second breach that's alleged, so there's the simple retention of DLA by Houlihan Lokey, and the second piece is that DLA supposedly gave confidential information. And I've discussed why that can't be an inducement or an absence of justification, because that's the decision the attorney makes. In addition, the confidential information that is supposedly given by DLA to Houlihan Lokey is identical to information that Houlihan Lokey already possessed. The reason we know that, Judge, is Houlihan Lokey has previously been sued and is pending a suit in federal court in Kansas by Ferrellgas related entities, and they're being sued for breaching a confidentiality agreement, and the confidential information that Houlihan Lokey obtained under that confidentiality agreement and then allegedly shared with others is substantively the same to the information that's alleged to have been provided by DLA law firm to Houlihan Lokey. And if Houlihan Lokey had that information by some other source, then the breach of giving it to Houlihan Lokey by DLA could not have harmed Ferrellgas, because Houlihan Lokey had the information otherwise. And on page 7, Your Honor, of our brief in support of our motion, you can see there the allegations that are made, and I won't read them to the court, but they are essentially identical. And the one allegation comes from the petition in this case, and the other allegation comes from the petition in the federal court case that I described. The primary argument that Ferrellgas makes in response, Your Honor, is that we're asking the court to consider, for example, the petition in the federal court case, materials that the court cannot consider on a motion to dismiss. We have cited the cases and the rules in our papers, Your Honor, and we cite those for the proposition and believe it's clear that the court can consider, for example, that petition in the federal court case. In this case, Ferrellgas cites that lawsuit and refers to that lawsuit and refers to the confidentiality agreement that was the basis for that lawsuit and demonstrates the confidential information that Houlihan Lokey received in being considered to be a financial advisor to Ferrellgas. That issue, I believe, Your Honor, if the court concludes that can't be considered, then the inconsistency will remain not considered until some later point. But if the judicial notice and the ability for the court to look at public documents and documents that are referenced in a pleading or attached to a pleading, and again, we cited the authority, if the court does that, then the motion should also be granted on the independent grounds that there's no damage to them. The confidential information that Ferrellgas claims DLA gave to us, to Houlihan Lokey already had. And damages are an essential element of the tortious interference claim, Your Honor. That's all, Your Honor.
No, let me back up a little bit on your judicial notice issue. Tell me about that again.
I think it's Rule 409, Your Honor, I believe, 60-40, and there's case law interpreting it, and then there's a body of law that's primarily developed in the federal courts on motions to dismiss and what can be considered as part of pleadings. And both parties cite, and I'm sure the court's well familiar with, there's well-established Kansas law that in the absence of Kansas law, the courts can look to federal courts' interpretation of the, if not identical, substantially similar rule. And those cases permit a court to consider, for example, publicly filed documents whose authenticity is not fairly disputed.
Well, where is this issue in the motion to dismiss this before the court? Where is it?
Well, they raised the motion, Your Honor, or raised the issue in their reply. And if you look, Your Honor, on page 2 and 3 of our motion to dismiss, we raised the judicial notice issue as well as the court's ability to consider exhibits to the petition and the court's ability to consider the content of records filed in another case. It's on bottom of page 2, top of page 3 of our initial brief in support, Your Honor.
Okay, and you didn't provide those? Where are they?
We did not provide the public record document, Your Honor. Obviously, if that's, we would ask leave to do so if the court, for the court's convenience, would do that. They're, as I say, Judge, they're a matter of, everything we rely on there is a matter of public record, but I understand the court's point.
Okay. All right, anything else on the motion to dismiss?
No, Your Honor.
Bethke? Are you ready?
Me, Your Honor?
Yes.
Yes, I am. I think I can cut through this pretty quickly by saying, first of all, this is a motion to dismiss. This is a pleadings motion. And, you know, some of them are close because of interesting legal issues, but I think, as I'm going to try to demonstrate, this is not one of them that's very close. Now, this is not my first time in Your Honor's courtroom. The last time I was here, you, in the kindliest, nicest way possible, threw me out of court on the basis of the fact that while I made a nice policy argument, my legal argument wasn't supported. And on this particular instance, I think I get to come in here easily, squarely in team law. So let me take it from the top. First of all, I don't think that Mr. May's description of our complaint matches what our complaint actually alleges. Our complaint...
Hold a second. Who's Ed Newberry?
Oh, Ed Newberry is also my restructuring partner.
Okay.
I'm getting a lot of help today too, Your Honor.
And I don't mind anybody sitting back there watching. I just want to know who's there. And particularly in case you start wrapping off any confidential information that I don't know if we're streaming today or not, but we might be. So go ahead.
So what I was saying, Your Honor, is that I'm not quite sure what complaint Mr. May was portraying in his argument, but it's not a fair reading of the one that we filed. The complaint that we filed alleges essentially that the Ferrellgas entities, the plaintiffs, hired DLA Piper to provide restructuring legal counsel in July 2018. Some of this should be familiar to you. The next month, Houlihan Lokey attempted to become our restructuring advisor. The Ferrellgas entities went with another company to do that, at which point Houlihan Lokey actively, with the knowledge that DLA Piper was our attorneys, went and procured DLA's assistance in attempting a hostile takeover and replacing our board with a board that would be more friendly to the idea of hiring Houlihan Lokey to be its restructuring advisor. And if you know a little bit about some of these...
They already had a relationship with DLA Piper?
So I'd like to correct the record on that front. What our complaint alleges in paragraph 20 is unknown to Ferrellgas at the time of its 2018 retention of DLA, and specifically Mr. Califano, had an ongoing relationship with Houlihan Lokey, a national financial advisory firm. We allege a relationship, and as the paragraphs after that go on to describe, it's a mutually advantageous business relationship. It is not an attorney-client relationship in the context of this bankruptcy. We were the client first. Houlihan Lokey may have been a client of DLA in various matters over the years, but we've made no allegation that Houlihan Lokey had retained DLA Piper for anything having to do with this restructuring. So I think at once, simultaneously, Mr. May takes a parsimonious view of our complaint. In addition, in his description, he alleges that the breaches that DLA Piper is guilty of is twofold. Number one, retention of Houlihan Lokey, and number two, exchange of confidential information. Again, that's not exactly what we allege. Our allegation, and it's included in paragraph 23, is that DLA provided advice to Houlihan Lokey concerning how to effectuate a board of directors change, particularly by using Great Bank, our fiduciary advisor to our ESOP, in the effort, all in violation of DLA's contractual and fiduciary obligations to Ferrellgas. So simultaneously, Mr. May, I think, makes this case more complicated and more simple than it is. And here's the way in which it's simple, and here's the way I think we squarely satisfy the pleading requirement, is that the elements required for tortious interference are there have to be a contract, the defendant has to be aware of it, defendant has to intentionally procure it, there cannot be justification, causation, and damages. We allege all of those things. Now, Mr. May says there's two reasons why, as a matter of law, we haven't. The first is justification. And he says that if you have an attorney relationship, a client, Houlihan Lokey should be able to rely on its counsel, DLA, to do its conflicts check and to make sure that DLA is not doing anything illegal. There may be some setting in which that argument works. Certainly as a matter of policy, but that's not the factual setting that we've alleged. We allege that we were the actual client of DLA Piper. Houlihan Lokey came along and procured the breach of that agreement, and they did so with the most bare motives possible, which is they wanted to be retained to be the restructuring advisor. And if you know anything about these very large public company restructurings, you know, and you can know because once they're in court, the fees petitions are all public. The fees for these restructurings are not it's not like in the movie Fletch where he says like, oh, I see you remodeled the garage. It must have cost you hundreds. It's in the hundreds of thousands and sometimes the millions. That's why we allege Houlihan Lokey procured the breach by DLA of its contractual and other obligations to us. There is no law in support of the fact that an attorney relationship, that it's impossible to procure tortiously the breach of an attorney relationship. There is no law, there's been no cases cited in support of that proposition. That would be an extremely novel ruling that is not supported by any law, and indeed the defendant cites none. So that's the first point, and now I can move quickly on to the second point, which seems to be that there was no breach because there's no damage because any confidential information that DLA gave to Houlihan Lokey they already had. Okay, so first, there is no reading of this complaint that's been filed in this case that could give rise to that conclusion. And second, there is no reading of any other public document that can give rise to that conclusion. There is a federal court matter pending between a Ferrellgas affiliate, not one of the plaintiffs in this case, against Houlihan Lokey for breach of a confidentiality agreement. That is where that case is at right now. There's been a complaint filed, there's been a motion to dismiss, but there is no ruling and nothing to take judicial notice of. In addition, while in that case, Ferrellgas's affiliate has alleged that Houlihan Lokey misused confidential information, there is no way to connect the dots between point A and point B, which is to say the confidential information at issue in that case, and we don't even know what the scope is the same confidential information that Houlihan Lokey procured from DLA Piper in this case. There's no way for us to know that until we get discovery in both cases. But all confidential information is not created equal. And to revert to an earlier point that I made, again, our allegation is not that Houlihan procured two breaches by DLA Piper, number one, retention, number two, sharing of confidential information. Our allegation is that there was a tortious interference with our DLA Piper relationship inasmuch as, in paragraph 23 in particular, DLA provided advice to Houlihan Lokey concerning how to effectuate a board of directors change, particularly by using Great Bank in the effort, all in violation of DLA's contractual and fiduciary obligations to Ferrellgas. So again, the motion to dismiss basis number 2 doesn't match up with any fair reading of the plaintiff's complaint in this case, and is also, I might add, unsupported by law. So I don't really have that much else to say in terms of argument, unless Your Honor has any questions. I don't think we're anywhere near where the motion to dismiss standard is at.
Okay.
May I respond, Your Honor?
Just a second. I'm thinking something through here.
Thank you. I apologize.
Ms. Rathke, was there some reason you didn't bring this claim along with the claim against DLA?
You mean in the first instance in your court?
Yes.
Yes, you might recall that at that time I did not know who the client was.
You didn't know about Houlihan Loki?
I knew there was a client because, as indicated in that complaint and in this one, Ferrellgas had, their general counsel received a bill directed to someone, not us, describing intelligence work performed on us. We did not know at that time that the client was Houlihan Loki, and I should say I strongly believed it was another client. I still strongly believe that that client is also a client of DLA. But the reason I didn't name Houlihan Loki in the original complaint with DLA in this court is because I really didn't know it was them.
I thought Houlihan Loki was mentioned in the earlier argument that we had.
It became clear during the course of the briefing. Other than that, I thought it was a company called Redwood Capital, which was a competitor to Ferrellgas. You may recall that.
Don't recall that name. Okay. Right. May I go ahead?
No, I'm sorry, Your Honor. Thank you. Your Honor, I will take the liberty to quote from the brief in opposition where Ferrellgas says, unbeknownst to plaintiffs, DLA already had an ongoing attorney-client relationship with defendant, and they cite to paragraph 20 of their petition. There is law, Your Honor, that supports our position. We've set it forth in our filings. The restatement supports it, and there's Kansas law, Your Honor, that says if parties are on, quote, equal footing in a relationship, then you're justified in taking the action that you took. And I think certainly it's fair to say that each party was a client of DLA's. Again, I'm accepting the allegations that are made in the case by Ferrellgas, and that strikes me as in the bullseye of equal footing. I'm puzzled by the comment that there's no ruling in the federal court case in Kansas, and what that could possibly mean and has any relevance escapes me. The fact of the matter is the complaint is a public document, and the court can take judicial notice of that. And I will leave, we quote from it in our filing, and I will leave to the court to satisfy itself that the allegations are substantively identical. And I'm sure the court will study the petition carefully in the briefing, but the notion that there's some breach other than a conflict of interest that was created a violation at the time of the retention of DLA by Ferrellgas, and this providing confidential information, and paragraph 23 was referenced at least once, if not more. But again, all that illustrates, Your Honor, that paragraph just illustrates why there was a conflict of interest. That's what that allegation is about. That's not a new breach or a different breach. The breach is, as alleged, is that DLA breached its obligations to Ferrellgas by representing Houlihan Lokey at the same time. That's all I have, Your Honor.
Okay. Let me hear what you have to say on your motion to stay for arbitration.
Okay, Your Honor, Mr. Greenfield is going to address that motion. I'm going to pivot the computer screen here, and he'll take it from here.
Good afternoon, Your Honor.
Good afternoon.
May I proceed?
Go ahead.
Thank you, Your Honor. As the court no doubt recalls, on June 15th, 2020, plaintiffs in this case filed Ferrellgas Partners LP versus DLA Piper LLP, also in Your Honor's court. And the allegation in that case was that, as Mr. May went through in some detail, that DLA breached either contractual or fiduciary duty to Ferrellgas by virtue of disclosing confidential information. Again, in that case, the client was described as a mystery client. DLA filed on June 26th the motion to compel arbitration and stay that case, relying upon its engagement agreement. Plaintiffs opposed the motion. The court held a hearing on that motion on July 28th, and although we don't have the transcript, reading between the lines, because an agreed journal entry was submitted by the parties on August 10th, we are assuming the court granted that motion at the hearing, and the journal entry reflects the court's decision. So on August 10th, Your Honor compelled arbitration of the Ferrellgas versus DLA case and stayed the matter before Your Honor pending that arbitration. That same day, Ferrellgas filed this case, and it also was lodged in Your Honor's court. In our opening brief in support of this motion to stay, we have a chart on page 3 and 4 that compares the allegations between the two cases. And suffice to say that the allegations against Houlihan Lokey are that, and I believe Ms. Rathke mentioned this in her argument on the motion to dismiss, that they now believe Houlihan Lokey was the mystery client, and that Houlihan Lokey caused DLA to breach its contractual and fiduciary duties to Ferrellgas. And that is in paragraph 36 of the operative petition in this case. So on the case Your Honor referred to arbitration, the allegation is DLA breached its contractual and fiduciary duties to Ferrellgas, and the allegation in this case is that Houlihan Lokey was the party who induced that identical breach. So in our motion for a stay, we demonstrate that under Kansas law, for Houlihan Lokey to be liable to plaintiffs here, DLA must be liable to Ferrellgas for breaching a contract. And the Debrecht case that we cite is right in the bullseye on this. And frankly, it's common sense. But an essential element of a tortious interference with contract case is that there be a breach of contract by a third party, and that the defendant in the tortious interference case induced it. All right, so that's our point, and I think it's fairly straightforward and really not disputed that if DLA prevails in the arbitration, then this case must fail as a matter of law. This case is entirely derivative of DLA's liability in the first instance for breaching either a fiduciary or contractual duty. That must be proven to recover against Houlihan Lokey. And so if DLA prevails on those issues, then by definition, Houlihan Lokey will prevail in this case. All right, so that's the setup for the motion for stay. And surprisingly, although it takes some work to to confirm this, the parties are really not in disagreement about much on this motion. There is no dispute that Your Honor has the inherent authority under Kansas authority to stay this case while the DLA and Ferrellgas arbitration is resolved. There is no dispute Your Honor has that authority. There is no dispute about the factors that Your Honor should consider in making the decision about whether to stay this case or not. And while there are several factors, the important ones here we respectively submit are whether judicial economy will be served by the stay, and whether whatever judicial economy benefits that there are from the stay are outweighed by prejudice to the non-moving party here, Ferrellgas. Okay. Right? So a review of the briefing here will reveal that there's no dispute that if DLA wins the arbitration with Ferrellgas, this case is over. Okay? So the judicial economy here is manifest. We have an unusual opportunity here.
How would this case be over? Part of the damage, as I understand, being claimed has to do with the increase in the expense that they've had because of the breakdown in the relationship with DLA Piper. Kind of an alienation of affection case with lawyers.
Yeah, okay, fair enough. Here's why it would be over, Your Honor.
So we've had somebody cheating in the relationship. Now, the arbitration doesn't have anything to do with the ethical relationship between a lawyer and client. It has to do with a contract that happens to be an attorney-client contract. But I don't think clients, and you have to correct me on this maybe, I don't think clients can be compelled to arbitration except for maybe fee agreements in some jurisdictions, or earned fees.
Yeah,
in some jurisdictions, like New York in this instance.
Yes,
Your Honor. I don't think, and the provision in the arbitration disputes, and it was troubling to me back then when I heard this the first time, was sending arbitration of an attorney-client relationship. And it says it's excluded. The provision shall not apply to any ethics or disciplinary proceedings. I'm wondering now, that with everybody being aware of the allegations and potentially there being at least a good faith basis in fact and law to make the allegations, is there, I'll leave it up to you, you don't have to answer because it'd be confidential, but I assume that some ethics complaint's been made somewhere, wherever, and you've thrown around Kansas rules of professional conduct, which if they apply, then I would think that would involve Stan Hazlitt in the disciplinary office, but if it involves some other jurisdiction, I would expect somebody's been advised of that, because as lawyers, we are not supposed to not do that if we become aware of some breach in ethics. But this, if there's a breakdown in the ethics that causes more expense, isn't that part of what they're claiming as damages? And that's not going to be addressed in arbitration.
Your Honor, they really are distinct and separate issues, because we are not contending that we are a party to an arbitration agreement with Ferrellgas or an arbitration agreement with DLA. We don't contend that.
But I think one of our other judges out here has compelled a non-party to an arbitration agreement, has compelled that non-party to go to arbitration. And there
are situations where that has occurred.
Matter of fact, I think Kelly may have taken the record.
Nobody in this case is suggesting that Houlihan Lokey is obligated to arbitrate, certainly not Houlihan Lokey. And so for purposes...
And you're not asking to intervene in the arbitration, are you?
We are not, Your Honor. We take as a given that this will proceed in parallel with the arbitration Your Honor has compelled. And so we are not moving for a stay of this case because we want to be in arbitration. We are moving for a stay in this case under this court's inherent authority to control its docket because this case would otherwise move in parallel with the arbitration. And the arbitration, we contend, and I think it's not disputed, may resolve this case, and it will resolve it if DLA prevails. And I thought Your Honor had asked why would that happen? Well, it would happen because the claim you compelled them to arbitrate is a breach of fiduciary duty and breach of contract case. Those breaches, the breaches that are alleged are the same breaches, the identical breaches that are at issue here that Ferrellgas alleges Houlihan Lokey induced. So in the arbitration, the question is whether DLA committed those breaches in the first instance. In this case, the allegation is that not only did DLA commit those breaches, but Houlihan Lokey induced DLA to commit those breaches. And our point, and again, not disputed, under the Debrecht case is, in a tortious interference claim, if you cannot prove that, in the facts of this case, that DLA breached either the contract or fiduciary duty, we are out, right? I mean, because if there has to be an underlying breach. And so if DLA prevails...
Arbitration would be binding? The arbitration would be binding here?
Yes, it would, Your Honor, in a collateral estoppel, and we cite the O'Keefe case for that proposition. And it really, frankly, although collateral estoppel is always, not routine, it's fairly straightforward, and the authority is clear that a final adjudication in arbitration would be binding on Ferrellgas, LP, and if it's adverse, that we could invoke that and dismiss this case. And again, all this is set out in the open, and it's not disputed. I mean, this is not disputed in the briefing. Right? So, back to the point, we do have an unusual opportunity here because we have an opportunity to watch from the sidelines, okay, and for free, to see if the arbitration resolves what will otherwise be a highly complicated case. Right? And free is important here and significant here because this case will consume a lot of the court's and Houlihan Lokey's resources without a stay. And I'll just hit some of the high points here. I mean, there are novel legal and damages theories here. I mean, the motion to dismiss that Your Honor is going to consider is perhaps Exhibit A, but it's certainly a preview of coming attractions. There are complex issues of privilege here that are going to come up absent a stay and come up fairly quickly. As you'll recall from the motion to dismiss, Ferrellgas alleges that Houlihan Lokey and DLA had an attorney-client relationship. But this case, and likewise the case in arbitration, wants to drill down on that relationship and their conduct together to make a claim that that DLA breached fiduciary contractual duties. There will be, likely will be, assertions of privilege with respect to any interactions of those parties that I suspect Ferrellgas will challenge. And that will happen fairly quickly because absent a stay, as Your Honor noted at the outset, there is pending discovery and deposition and written discovery that will implicate those issues. In addition, because Ferrellgas has to prove that DLA breached either the contract or fiduciary duty in this case, right? They have to prove two things in this case. They have to prove breach and that Houlihan Lokey induced it. They only have to prove breach in the arbitration, but here they have to prove breach and that we induced it. They're going to have to try to take discovery in some fashion, I suspect, about DLA's conduct because the whole basis of the petition, both that you compelled to arbitration and in this case, is they didn't know what was going on. They only recently discovered it. So they don't have a recipient witness to all this. So that implicates Your Honor's order compelling arbitration because as we demonstrate in our briefing, and it's not disputed, the available discovery to Ferrellgas in the arbitration is quite limited. I mean, it's limited essentially to an exchange of documents. And so we anticipate that should they try to use this case to take discovery that would implicate issues in the arbitration that DLA may well object, and certainly we could. And in fact, one of the bases for this motion is that this entire lawsuit, this one is simply an end run around, Your Honor's order compelling arbitration under the AAA commercial arbitration rules, because none of the discovery that is currently before the court is permissible against Houlihan Lokey in that arbitration. You can't do that kind of discovery against us, a non-party, in the arbitration. So those are just some of the high points, but there's no doubt more. But the short version is this case is going to be hard fought, very complicated, and very expensive for Houlihan Lokey. And the only way we can take advantage of the opportunity to see if DLA prevails in the arbitration is for the court to grant a stay pending that result, okay? Because without a stay, we're going to go forward. We're going to spend all that money, the court's going to spend all its time, and DLA can prevail, and all of that time, money, and effort will have been wasted. Okay? Now, on top of that, we don't think the delay will be very long, right? In our experience, expect Your Honor's experience.
Let's get back to that being wasted a second.
All right.
The being wasted is still based on the O'Keefe case, right?
It's based on our argument, again, undisputed, that the result in arbitration, if it's adverse to Ferrellgas, will be binding here and would be collateral
Because the
estoppel.
O'Keefe case.
Correct, Your Honor. And again, not disputed here. We also believe that, you know, the length of any stay will be modest. Our experience, we assume Your Honor's experience, is that the arbitration will move expeditiously, and in most cases, probably the overwhelming majority of cases, will be resolved well before this case could have been resolved or taken to judgment. And Ferrellgas does not disagree with that. I mean, so in all likelihood, in fact, in the overwhelming majority of cases, we would expect a stay of this case while we see what happens in the DLA arbitration will be relatively brief. Okay? All right. So the question of prejudice to Ferrellgas. All right. So I respectfully submit, Your Honor, that we have demonstrated that there's a significant potential for a savings in expense, cost, and time and judicial economy with a stay if DLA prevails. The other factor that's relevant here is, well, what prejudice would there be to Ferrellgas? They're the non-moving party. And they really don't spend a lot of time on this. In their opposition brief, they basically devote a sentence to it. And it's on page 5, and they say, a stay would unduly prejudice Ferrellgas, which has already been immensely harmed by Houlihan Lokey's conduct. Among other things, Ferrellgas has been damaged by Houlihan Lokey's conduct in the eyes of the investing public. Its share prices have dropped, and it has been required to incur significant legal fees to rectify Houlihan Lokey's wrongful conduct. Yeah, that's it. That's the argument that they will be prejudiced. And a couple things are clear about that. One is that it's all in the past. All right, there's no contention here by Ferrellgas that a stay will cause harm to them. Won't cause any of that harm because all that harm has already occurred. The closest they get to arguing that the stay will cause some harm that has yet not happened is, again, the same place in the reply brief. They say its investigation into the scope and extent of Houlihan's wrongful activities will be delayed. Okay. Well, that's true. Okay, I mean, it will be delayed. We think briefly delayed, not unreasonably delayed. But the fact of the matter is, they don't allege that the delay will cause that investigation to be ineffective or come out differently. And as we know, and as we've been discussing, it may well be proven to be unnecessary, which is kind of the whole point. So We respectfully suggest, Your Honor, that, and our reply brief lays this out in, we think, pretty good detail, based on what's undisputed here about DLA arbitration in this case and the potential benefits of waiting and the brief amount of time we have to wait to see what happens, that this presents a textbook case for the grant of a stay pending the result of the arbitration.
If Ferrellgas prevails in the arbitration, not DLA, is that going to be binding in this case against you?
No, it will not, Your Honor. We're not a party to the arbitration. But that's true no matter what. The state doesn't have anything to do with that. It does, I mean, you know, the state doesn't make that true or not true.
That's getting back to the O'Keefe case, which is the only thing that you really cited. It's because of the O'Keefe plaintiff being in privity with the predecessor in interest.
Well, privity is really not an issue here because the party's identical. I mean, it's the same party. I mean, it's the exact same party. So,
You're assuming DLA prevails.
well, I'm not assuming it. I'm just highlighting for the court that they could. I think we'd all agree they could. Is it a coin toss? I don't know, but they certainly could. And so the price of admission here is pretty low. It's a brief delay while we see if they do. And if they do, the benefits are significant. If they don't, we move ahead. I mean, and again, very little, if anything, lost according to Ferrellgas by doing that. And there is a significant amount to be gained by waiting to see what happens. With that, Your Honor, that concludes my argument, unless you have any questions.
Thank you. Ms. Rathke.
Thank you.
Your Honor, I'm aghast and a little bit furious. Petition includes as an exhibit the contract between DLA Piper and Ferrellgas. And you may remember the hearing with DLA, they were very, very heavy-handed on this point. This contract says the existence and content of the arbitration proceedings, as well as any arbitration rulings and awards, shall be maintained by the parties as strictly confidential. I cannot even confirm that there is an arbitration. There is no judicial economy to be maintained, and that is because of DLA Piper's award. Now, that said, Houlihan Lokey's words were, we get to watch from the sidelines for free. You absolutely do not. And this is exactly, these are people who don't believe that the rules apply to them, and that's what we're seeing here. Nobody believes that the rules apply to them. They only apply against Ferrellgas. No one will know. No one should know. People apparently do know what's going on in this arbitration that I can't even confirm exists. People seem to know an awful lot about that arbitration that I can't even discuss as existing. That is a breach, and I'm not sure that this is the forum to bring it up, but I will. But there is no judicial economy to be gained from waiting for an arbitration, even if there is one going on, which I cannot confirm. That is all I have. That is outrageous.
May I respond, Your Honor?
Hang on, I'm looking at section 6 and the second
Of what?
paragraph.
Of what, Your Honor?
The attachment to the petition.
Confidentiality? Section 6. Okay. I'm with you, Your Honor. I have it.
So the fact, Ms. Rathke, the fact that the arbitration and compelling arbitration was the subject of our other lawsuit in the hearing that we had.
I believe I can talk about that, yes. Beyond that, I cannot speak. And I'm a little surprised that anybody else here has knowledge of that.
I didn't claim to have any knowledge of it other than what's public record in your, I mean, we pulled it off CaseNet, Your Honor, what the proceedings in the other case. It's a matter of public record.
Mr. Greenfield says it should be short. The indications are that this shouldn't be difficult.
I said my experience is that we would expect the arbitration to proceed expeditiously. I mean, and if it's different.
I don't think you can blame Ms. Rathke for having the antenna activated by your comment and her knowledge of the agreement with DLA Piper. So,
Well, if I might address that, Your Honor.
whether or not there's been a breach by anybody, that's not before the court. If this is a question of whether or not we stay this case pending arbitration that was ordered for a different case.
Right, and if Your Honor, the confidentiality agreement, you know, the arbitration agreement that Ms. Rathke cites says that the existence of the arbitration proceedings, its award, et cetera, are strictly confidential, except subparagraph I, to the extent that a disclosure is required by a court or other governmental body of competent jurisdiction. I mean,
We're not there.
Well, we aren't there, but the fact of the matter is, while this agreement may suggest that between these two parties, the results may be confidential, that doesn't mean it's not relevant and discoverable in this proceeding, and that we could not rely upon it. I mean, maybe it's under a protective order, but the fact that there's an adverse may I finish? I mean,
Your
the fact
Honor,
that there's
Hang on a second. You really kind of jumped in the middle of what she was saying and I was inquiring about.
I apologize. I'll be quiet, Your Honor.
Your Honor, if Mr. Greenfield has authority to waive confidentiality in the arbitration that may exist with DLA Piper, I would agree to that right now.
Can I speak now? I mean, is that all right?
Go ahead.
I don't. Why would I have that authority? I don't have that authority. My point is that the fact that something may be confidential does not preclude it being discovered in a lawsuit. It happens every day. We use protective orders for that. Look, the notion that Ferrellgas can lose an arbitration can lose the claim, the DLA, and that not have any ramifications because of a engagement agreement says that it's confidential. That doesn't bind my client. It doesn't bind the court. I mean, it may dictate that we do it under a confidentiality agreement or a protective order. It doesn't mean nobody ever gets to know about it. I mean, I've just never heard of anything like that. And of course, so, I mean, barring some authority for the proposition they can lose and nobody ever gets to know about it, our motion is well taken. And they certainly don't raise that issue in opposing the motion.
You're not going to adopt that provision in your retainer agreements then, right?
You know what? I may adopt a couple of them. They seem to work pretty well, but I'm not sure that one's one that we're considering.
I don't know. I've got some serious reservations about lawyers compelling clients to arbitrate.
Agreed.
And give up substantial rights when they agree to arbitrate. Now, maybe a different rule for big companies, but I don't know. It's a international law firm, I think, isn't it?
I believe it is, and Ferrellgas is a sophisticated party. But again, if there was an issue there, I would have expected it to be raised by Ferrellgas before Your Honor as part of the motion to compel the arbitration. All this is kind of a side inquiry, if you will. It doesn't have anything to do with our motion.
The provision was read by myself, and I understood it to not apply to the ethics.
I would think it would be very difficult to shield an ethical violation by referencing that, Your Honor. But again, that's got nothing. That's not what we're here about.
Right. All right. Anything else on the motion to stay?
Nothing on the motion to stay, Your Honor.
And I think the other two motions for, that had to do with discovery, extending time for discovery and the protective order, those were related to the motion to stay?
They were actually related to both, Your Honor. I believe the relief we requested on the written discovery was to delay that until 21 days after the ruling on these motions, and the basis for that was if Your Honor grants either of them, obviously the responses are moot, to stay for a while, potentially, motion dismissed moot entirely, but that if Your Honor denies the motions, the 21 days was a reasonable time to put that information together and respond to that discovery. The protective order on the deposition notice is essentially the same. We're asking for the same relief. I mean, if you deny both motions, we recognize we're going to have to respond to that, and just wanted some time to do that after those were ruled.
Well, Matt Neiman is not a party. Where does Matt Neiman come from?
Well, where does he live, Your Honor?
Well, no, you're the.
Yeah, he's
I'm the one who noticed him. He's one of the guys at Houlihan Loki that dealt with Ferrellgas. So he's not a party, but he's an employee of a party.
So this is not a corporate representative deposition. This is just a fact witness.
That's correct.
That's our understanding, Your Honor.
Thought I might ask him a few questions.
Okay. And in terms of protective order generally, do you expect to be getting into matters that are not generally matters of public, for public disclosure, something that's already recognized as protected, confidential, private information?
So, no, Your Honor. I mean, the only sort of confidential business information is that involving our client, and I do not anticipate going into that.
It was not that kind of protective order, Your Honor.
I'm just saying, if you anticipate that that's going to come up, I just suggest that you do it now. Just go to the port website, get the form that I have out there, use that form and tailor it to this case. You know, add the caption, add the grounds for what you expect the confidential information might be, and get it on file so it will facilitate discovery, so that that's not going to be an issue that you have to spend another month or two on trying to get an order together. I've already got the form out there. I've spent a lot of time putting that form together with a couple of different research attorneys and consultation with the federal magistrate who deals with protective orders, and came up with a form that I thought balanced the needs for discovery with the Kansas Open Records law and confidential protected information that's already recognized as confidential. We're not creating anything new. So the order was crafted to balance those interests, and so I prefer you use that. I know we've got several thousand creative lawyers, very creative lawyers just in our Johnson County, Kansas City metro area that practice out here, and it gets rather tedious to keep fly-specking all the different ways that people can draft protective orders. So if you just use that form and add to it, don't take anything away from it, add to it what you need for your case, and you're good to go.
Yes, Your Honor.
I've got some key points I look for in the form, so I don't have to fly spec everything, and if it's my form, I'll sign it. If it's not, it'll be more delay. All right, anything else on any of these motions?
No, Your Honor.
I understand that, Your Honor, and we hope not to have to get there, but if we do, we'll certainly start with your order. Our motion for a protective order was to delay that, essentially, that discovery not be had.
Well, I was trying to figure out who in the world this guy was that you would have standing to even come in and say we want to delay this guy's deposition.
Fair point, Your Honor. Yes, he's a corporate Yeah, he's within Houlihan Lokey, so on behalf of Houlihan Lokey, we're raising the issue.
So his answers are going to be binding on Houlihan Lokey or not?
No,
I
it's
would-
not a corporate representative deposition. It's merely a fact witness deposition.
Okay, if it's not binding on Houlihan Lokey, is that what you're saying, Sarah?
Might be.
I'm saying we're deposing him as a fact witness. I mean, whether or not he's high enough to bind the company, that I currently have no knowledge of and no information and no opinion on, but we're not seeking him as a Kansas 30B6 equivalent witness.
That's up to the defendant to designate anyway, so
Right,
you may like his answers.
I hope so.
All right. Are you ready?
Yes, sir.
I'm
Yes,
not
sir.
going to write a decision on this. I think on the motion to dismiss, that there's ample pleading sufficient to go forward. We may be facing these issues in summary judgment later on, but I'm not going to make that call on the motion to dismiss. I think you can go forward. We probably will end up seeing, there's a likelihood that we'll end up seeing a motion to amend, and as discovery proceeds. And if it's hard fought, that's what litigation's about. That doesn't bother me at all. Matter of fact, I like hard fought when it's good lawyers like yourselves. Hard fought when it's all slamming the table is a wholly different thing, and very tedious. But hard fought intellectually, I'm all for it. On the motion to stay pending arbitration, I think it doesn't seem to be equally applicable in terms of the binding nature of any arbitration. And this confidentiality provision in the arbitration rule does have me somewhat concerned as to how that would be implemented by the defendant if DLA Piper won in the case, in the arbitration case. So I'm not going to stay this litigation pending the arbitration. If the case was originally jointly brought against Houlihan Lokey with DLA Piper, I might have considered compelling Houlihan Lokey to participate, but that's not the case before me. On the protective order, that's denied. I think the plaintiff can go forward with discovery. On the motion for extension of time for discovery, it's granted as a practical matter because I don't expect you to have the answers to discovery available in your pocket this afternoon, so you're going to have some period of time. And I'm denying the motion to dismiss and denying the motion to stay, so the responses to discovery are due as they were served. But we'll come up with a definite date for those responses and a definite date for you to file your answer. And if you'll put together a protective order generally so that we don't have that problem come up later in discovery, that would be a good idea. If you don't do it and the issue comes up, one or the other of you is probably going to remind me that I said this a long time ago. I will have forgotten. Good thing is Kelly's fingers didn't forget and they're in the record. You guys always start your arguments with, "You'll recall, Judge." Well, I love that argument because I don't know, what was my last count? 405 open cases. If I can recall what I did this morning, I'm lucky. So, Ms. Rathke, if you'll put together a journal entry of the rulings on those 4 motions under Rule 170, get that started.
Your Honor, this is Mr. Greenfield. You indicated you were going to give us a date certain on the answer and the discovery. Can we discuss that at this time?
Yeah. Yep. I want to do as much as we can here. I've got, trying to get my calendar. Let's see if we can set some dates while we've got everybody here. Let's see if we can move this case along.
Your Honor?
Yes.
Your Honor, this is Jim Griffin. Can you hear me?
Who was? Oh, okay, yeah, I see. I see your box lit up green. Go ahead.
I can't tell from my end. The normal under 6212 B or AB, they would have. Wait a second. No, it's 2. It's B2. If the court denies a motion or postpones this disposition until trial, a response to pleading must be served within 14 days after notice of the court's action. So the normal answer date would be 2 weeks from today.
Well, it's the ruling's not in the journal entry. Is that run from the date of the journal entry or pronouncement from the court?
It would probably be from the journal entry.
That would be our understanding, Your Honor.
So you're not going to be before October 20th. Realistically, when can you get your answer on file?
Well, I need to, without having a chance to talk to the client, I'd say the 27th would give us enough time, Your Honor.
Okay. Answer buyer before October 30th, 2020. And the discovery responses,
I think the same date would be fine, Your Honor.
October 30th, 2020.
Yep.
And do you want to set some dates right now? Case management dates?
Sure, Your Honor.
Fact discovery?
I think, Your Honor, I'd like to go through those with with our client, the court's form of order, and just make sure that everything works with everybody's schedule at Houlihan. If we could set a date for a case management conference, that might be perhaps a better way to approach it. Then we can have that discussion with our client.
Okay, we're running out of time. That's why I just soon do it today. As we approach the end of the year, I'll tell you what our practical issue is packing and getting ready to move, figuring out what we can take, what we need to take home before we take to the new courthouse, what the county is going to move for us. It's very convoluted and confusing, so much so that a moving company was hired to help us go across the street. A moving company to organize the process. Consulting company, I guess. So anyway, we have to figure all that out, and the docket's a mess because of COVID and pushing cases down the line. So I want to include in this case that deadlines that we impose are not stayed under the Supreme Court's administrative order. I'm not sure how much longer it's going to stay in effect, but administrative order is 20-PR-58, and that was readopted on subsequent orders. They're up into triple digits now with administrative orders, not all of them having to do with COVID, but a lot of them have. And one of those orders included a stay of deadlines, including court-imposed deadlines, statutory deadlines, statute of limitations, and there's a provision for the court to find them exempt on particular cases, and I'm finding the the stay provision, that this case is exempt from that stay provision. So we're going to go forward. And I'm afraid if we put this off, we're going to be putting it off more and more instead of finding a reasonable date to end fact discovery. The facts are, as John Adams said, stubborn things, but they're getting old. They've already occurred. So,
We were happy to meet with Ms. Grathke in the standard practice and submit a proposed case management order to the court.
okay.
I'd
Jill,
be really surprised if we can't do that.
okay. You just go to the, again, to the court website and the Division II page and get my case management order and read through it and fill in the blanks. And Jill will give you circulate email with Jill, and she'll give you a pretrial conference date and maybe even be able to put you on a jury calendar. The sooner the better on the jury calendar.
We will do it.
Your Honor, how long, what's your timeline typically for civil jury trials? I mean, what should we be working within?
For the trial itself, I'd like it to be over in a day and a half.
But I mean, from now until when? Like a
I'm
year?
only kidding. It depends on the case. They're complicated. Multiple party cases are going to take longer because it takes so much longer to schedule somebody's deposition. And we've got two
How
parties.
far
in
out
this
are you
case.
setting trials?
Jill?
I can email you our trial docket, jury trial docket for 2021 and into the first part of 2022, just so you can kind of see where we're at. Is it going to be just a 5-day or shorter trial, or is it going to go into a second week?
5 days about right.
Yeah, I mean, I'm sure Sarah would probably know, it's her case, but we haven't really had a chance to evaluate it. So there's going to be experts and things of that nature. It could slop over into 2 weeks.
6 people involved.
Jill, can you give us a case management date somewhere around the end of October, early November?
Can you do November the
ask them?
2nd at 11 o'clock?
What are we doing that day? I'm asking one of my colleagues here.
It'll be by video too, also. So,
Works for me, Jill.
It works for us.
You got my phone and my calendar.
I think one of us can attend that by video on the 2nd, Your Honor.
November 2nd at 11 for case management conference. If you've already got a case management order filled out and at least a pretrial conference date that you agreed on to put in the document, you can upload that and then we won't need to meet on November 2nd. If you don't have your dates nailed down in the document, then we'll get on the video and we'll work through what's the problem and we'll come up with some dates that work for everybody.
Thank you, Judge.
Okay, thank you, Your Honor.
All right. It's
Thank you, Your Honor.
always a pleasure to listen to lawyers that are prepared and know their stuff, and I enjoy having you. So,
Thanks, Judge.
is there anything
Thank you,
else
Judge.
that we can address today?
Didn't get kicked
thank
out
you.
the second time.
Don't take it personally.
I won't.
Yet. Yeah, Judge.
Yeah, we got summary judgment coming. All right. Guys, have a good day. You may withdraw.
You too.
I'm gonna stop
Thank you,
the
Your Honor.
record. All right. You have a good day.
Recording has stopped.